Sure. Huh? Yeah, man.
Thank you, Fred.
Of the court's decision, based on what we thought was perhaps some erroneous or misinterpreted information in the judge in your decision.
I would ask you to just do it in a written form. I mean, just so that we keep track of these things, the numbers and so forth. That's how we keep track of these things. It's sort of the support for our keeping in this case, record keeping in this case. Now we have several persons appointed to assist the defense, and Janice Mitchell, who is an investigator, and she's a mitigation investigator. James Karkovich, PhD, and also Christopher Giannetti. Sorry, I mispronounced your name. Mr. Lashley, have you had an opportunity to speak with these individuals?
Yes, sir. Yes, sir.
Okay. What about with your counsel? Have you had an opportunity to confer with them?
Yes, sir.
Okay. We have not set a trial date in this case, and counsel, I suggested, but it's really going to be up to Judge Harris if we don't do it. Well, he's going to be part of any date setting because of his schedule, and I know counsel, Mr. Grant, you've got a case that you're uncertain about when it's going to, whether it's going to be at the end of March or the end of May.
That's correct. In the process of doing testing on our client, we anticipate probably a follow-up motion because there's some additional testing he needs that he can't do, and there's going to be another individual who we're going to ask what our position is going to be in terms of scheduling this.
All right. Okay. I prefer to do those things usually late on a Monday afternoon, because a lot of times that's when it works out best for counsel, and I just want to get an update. And Mr. Lashley, the reason I'm doing that is I just want to make sure everything is moving along, and it may be hard to get all your counsel and the state's counsel here on that particular time. That's why I do it by phone. Counsel, if you would, defense counsel would wish that Mr. Lashley be here in the courtroom and we have a speakerphone, we can arrange for that if you confer with each other and see if you think that's necessary.
And we'll discuss it, and we probably could waive his presence if it's simply for scheduling purposes.
Okay, all right. But anything else we need to discuss now? There's been a time waiver in the case. We talked about that in chambers. Judge Harris wanted to know that. Okay, anything else we can do here today?
Not that we're aware of this time, Your Honor.
Okay.
No, Your Honor.
Okay, Mr. Lashley, is there anything you want to ask me? And if you do, I suggest you ask your counsel first and then ask me, all right?
No, I don't got no questions.
Okay, all right. Okay. And the issue of haircuts, I guess that got resolved by your cutting your own hair.
Yeah.
Okay, all right. Okay, then these proceedings then are closed for the day. Thank you very much.
All right.
To be filed by defendant. One of the things we're looking up and trying to read particularly the decision is State versus Herring, which is what you cited to us in chambers. That's a 2014 Ohio 5238, and we're trying to get the implication of that. We just haven't had a chance to read it. Also, counsel for defendant, there was another motion, but I wasn't sure if it was a written motion or you made an oral motion.